Good evening, students. Welcome you all to StudyIQ IS English. All of you must have heard about that our country has got a new Chief Justice. Yes, Justice Surya Kant has been appointed as the 53rd Chief Justice of India. He will be holding his office for a period of 16 months. In today's video, we're going to discuss what is the appointment process for Chief Justice of India. Apart from that, we'll also briefly discuss what is the appointment process for other judges of Supreme Court and High Court. I must remind you, Chief Justice of India not only holds judicial authority, but he also holds administrative authority with respect to the Supreme Court. He is the master of the roster. That means he is the person who finally decides which case will be given to which bench in the Supreme Court. So in today's video, we'll see the appointment process. Apart from that, I will also briefly mention a controversy that erupted in 1970s regarding appointment of the Chief Justice of India. So let's move forward. See, Justice Surya Kant has been appointed as the 53rd Chief Justice of India. Obviously, he has assumed charge on 24th of November. Now, before being elevated to the judge of Supreme Court, Justice Surya Kant, he has been a judge of Punjab and Haryana High Court. For a brief period of time, he has also held the office of Chief Justice of Himachal Pradesh High Court. And I would like to remind you that he has a distinction of being the youngest Advocate General for the state of Haryana. Yes, he has the distinction of being a youngest Advocate General for the state of Haryana. Now, when I talk about the procedure for appointment of Chief Justice of India, I would like to remind you there is no specific process. Article 124 does not mention any specific process for appointment of Chief Justice of India. Article 124 states the appointment process for judges of the Supreme Court, but it does not specifically state the appointment process for Chief Justice of India. So in India, since independence, there was an unwritten convention. The convention goes like that. The senior most judge of the Supreme Court was appointed as the CJI. That means the person who holds the highest seniority in Supreme Court will be appointed as the Chief Justice of India. Now, this was the convention that was established at the time of independence, and from then till now, this convention has been adhered by all the governments. And there was an aberration in 1970s that caused churning in the judicial circles. I would tell you, in 1958, the Law Commission of India, it gave instructions, or it gave advices to the government. It stated that it is not important that the person shall be appointed as CJI only on the basis of its seniority. There can be people who can be less senior, but they can be equally competent or even more competent than the senior-most person. So, apart from seniority, the government shall also take into consideration the performance, the efficiency, or we can say the judicial acumen of a candidate. But the government did not accept this advisory. The government stated that if the government start appointing CJI at its own whims and fancies, so the government will be alleged, or it will be alleged that the government is trying to intervene in the appointment process of CJI. So that's why the government in 1958 did not adhere to the advisory that was given by the Law Commission of India. So, till 1970s, the convention was the senior most judge was appointed as the CJI. But this convention was put to rest by Srimati Indira Gandhi. Obviously, she was the PM then. What happened in 1973? She appointed Justice A.N. Ray. Justice A.N. Ray as the Chief Justice of India. Now, that point of time, he was not the senior most judge. At that point of time, there were three judges who were more senior to Justice A.N. Ray. The judges were J.M. Shalat, K.S. Hegde, and A.N. Grover. So when the Indira Gandhi appointed Justice A.N. Ray as Chief Justice of India, she superseded these three senior judges. Now these three senior judges, they resigned in protest. So now it caused churning among the judicial circles in this country. Various high courts, even Advocates Association, so there is concern that this selective appointment of Chief Justice of India, it is somehow signaling that the government is trying to intervene into the appointment process of CJI. Again in 1976, the government appointed Justice Beg as CJI. At that point of time, Justice H.R. Khanna, Justice H.R. Khanna was the senior most judge. So rather than appointing Justice H.R. Khanna as the senior most as the CJI, government appointed Justice Beg. Again, there was churning in judicial circles. So again, the government was accused of intervening in the independence of judiciary. Now, the government also had its qualms against Justice H.R. Khanna because Justice H.R. Khanna was the judge who gave a dissenting opinion in a very famous judgment by the name of ADM Jabalpur versus Shivkant Shukla. Now, this judgment was given in the wake of national emergency. At that point of time, the government was imprisoning people. The government was incarcerating people on the grounds of detention order. So emergency was in force. Article 21 was suspended. So the government was issuing detention orders and it was incarcerating people left, right, and center. So when these people used to go to Supreme Court and used to file a writ petition, as Article 21 was already suspended, so the court rejected these petitions by stating that Article 21 has been suspended. So you cannot approach us. But Justice Khanna, he stated Article 21 is not the only article that protects the liberty. There are multiple articles in the Constitution that protects the liberty of an individual. That means even by suspending Article 21, the government has still adhered to the procedure of law while it is imprisoning or incarcerating a person. So when Justice H.R. Khanna gave this dissenting judgment in ADM Jabalpur versus Shivkant Shukla, the government was infuriated. So that's why the government did not appoint Justice H.R. Khanna as CJI. In his place, Justice Beg was appointed. So obviously, Justice Khanna also resigned. Now moving on to appointment of the judges of Supreme Court and High Court. So Article 124 simply states that the appointment of judges of the Supreme Court and High Court. And Article 124 talks about judges of Supreme Court. Article 217 talks about judges of High Court. So Article 124 specifically states that the judges of the Supreme Court, they will be appointed by the President, and while appointing judges, the President will consult the judges of High Court and Supreme Court. Right? Now the question that surfaced, it was, who has the final opinion in appointing judges of the Supreme Court? Who is the authority that has the final say? Is it the president of the country or is it the judges with whom the president has to consult? So the question was laid to rest by a case by the name of SP Gupta versus Union of India 1982. It's a very important case. Now what happened? I'll give you a brief backdrop of this case. In 1980s, various judges of high courts, different high courts, they were transferred. The judges were transferred. Now the government was transferring judges. Now the advocates fraternity, it was quite apprehensive. Advocates filed multiple petitions in the various high courts as well as in the Supreme Court. They alleged that the government is trying to undermine the independence of the judiciary. It is transferring judges at their whims and fancies. That means the judge who is not giving favorable judgments in the favor of the government is transferring the judge as a means of giving him the punishment, as a means of punishing him. So petitions were filed in multiple courts, and all these petitions were clubbed together and Supreme Court heard the petition. Now the question came up, who has the final authority in appointing judges of High Court and transferring them? So the court stated that the word consultation, because the word consultation is mentioned in Article 124, 217. It specifically said the president has to consult the Supreme Court and High Court judges while appointing a judge of Supreme Court. The president also has to consult the judges of High Court as well as the governor of the state as well as the judges of Supreme Court while appointing a High Court judge. Now the question was, what is the meaning of word consultation? Does consultation means concurrence? Does it mean that whatever advice is being given by the judges, whether of Supreme Court or High Court, the advice would be binding, or whether this advice is just like an advisory? That means the government is not bound to follow it. Supreme Court stated consultation does not mean concurrence. That means president has the effective power, he has the final say in appointing judges of high courts as well as transferring them. So that means judiciary can give its advices, but the final say is in the hands of the president. Now this judgment was somehow shocking for the judicial community. And in multiple cases, for example, Subhash Sharma versus Union of India. Supreme Court made certain observations. Supreme Court stated, if we want to preserve judicial independence in India, it is important that CJI, Chief Justice of India, shall be given the prominent position. That means if CJI is forming a certain opinion, the opinion shall be given the utmost primacy. That means the CJI shall be the ultimate deciding authority, because he is the person who has technical experience, who has technical knowledge, who has experience, who understands who would be a better judge. He can evaluate the merit of a person on the basis of experience and track record. So the court stated that the office of CJ, he shall be given a prominent position in making appointments to higher courts, high courts as well as Supreme Courts. Now a case came up before Supreme Court in 1992. The case was as Supreme Court Advocates and Record Association versus Union of India. Now in this case, Supreme Court categorically stated that we understand independence of judiciary is quite important. Without an independent judiciary, democracy won't sustain for long in this country. So that's why it is important that judiciary shall be independent. And to ensure the independence of judiciary, it is important that government shall have minimal role to play in appointment of judges. Because if government has the final authority to appoint judges, the judges who are appointed by the government, now judges will always try to be in the good books of the government, because they know that if judges do not give judgments in the favor of government, the government will never elevate them. They will never appoint them to Supreme Court. So court said it is important that the judicial independence shall be maintained, and for that purpose, CJI, Chief Justice of India, shall be given primacy in appointment of judges of Supreme Court and High Court. That means appointment process or the final seal on a name of a candidate will be made by the president, but the opinion of the Chief Justice of India shall be of final importance. That means if CJI opines that a particular person shall be appointed as the Supreme Court judge, even the president cannot negate his opinion. But the court said the rule of law states that a single person's opinion cannot be given utmost priority, because anyway a single person, he can become victim of nepotism. Single person, he can show nepotism. So that's why the court stated the CJI also has to take opinion from his fellow judges. All of them will collectively make an opinion, and that according to that opinion, the president has to make appointments. So this was a new framework which was laid down by the court in Supreme Court Advocates and Record Association case. It is also known by the name of second judges case. So from there onwards, a process started that culminated in establishment of Collegium system in India. Now when Supreme Court gave this judgment, the government was really in flux. The government stated, till now we have been appointing judges to the Supreme Court and High Court, but now judiciary is taking our power, it is usurping our power. So now we'll do one thing, we'll make a presidential reference to the court under Article 143, and we'll ask the Supreme Court to clarify its judgment. We'll ask the court that please clarify your judgment. What do you mean that CJ will have the final authority to appoint judges? Supreme Court accepted the reference and Supreme Court clarified its judgment. Supreme Court stated, yes, appointment to the Supreme Court and High Court, it will be done on the opinion of Chief Justice of India, but the opinion will be formed by him by consulting his four senior-most judges. Now, when the Collegium, this is a body which is called as Collegium. So when the Collegium gave opinion to the president that particular candidate shall be appointed, or rather he shall not be appointed, the president at most he can refer the opinion back for reconsideration. But if the Supreme Court still persists with the opinion, the president has no choice, but he has to appoint that person as the judge of Supreme Court. So the Supreme Court in this particular case, presidential reference stated again that judiciary will have a primary role in appointing judges to Supreme Court and High Court. Now in 2014, BJP came into power. Now BJP came with thumping majority. Now BJP tried to change this appointment process. So BJP brought in 99th Constitutional Amendment Act, and it established an authority by the name of NJAC, National Judicial Appointment Commission. Now this commission consisted of CJI, two senior most Supreme Court judges, the Union Law Minister, and two eminent personalities. Two eminent persons. Now, who would be these two eminent persons? Any person who will be appointed by a committee that will comprise of leader of opposition, PM, and CJI. So these 6 people will be considered to be members of NJAC, National Judicial Appointment Commission, and this NJAC will decide who will be appointed as a judge of Supreme Court and High Court, even who will be transferred from one High Court to another. Now this constitutional amendment was challenged before the Supreme Court. The petitioners contended that this particular amendment, it is impinging upon the independence of judiciary. They stated independence of judiciary is the part of basic structure of the constitution. Because now NJAC will consist of law minister. NJAC will also consist of 2 people who are not from legal background. So now again this NJAC is taking away the judicial primacy in appointment of judges, and it is giving the primacy to the executive. So now the court stated yes, this is a major concern, because in NJAC 3 people will be judges and 3 will be from non-judicial background. So there can be possibility that the people from non-judicial background, they can, because 2 people had veto power. If 2 people stated that a particular selection will not be made, so the selection will not be made. So the Supreme Court stated it can be possibility that 2 eminent personalities, they can veto the proposal given by the Supreme Court judges. So that means the primacy of judiciary in appointing judges, it will be taken away. And if the primacy of judiciary in making appointments to higher judiciary will be taken away, the role of executive will increase. And increased role of executive in judicial appointment, it will be a very serious blow to the independence of judiciary. As independence of judiciary is part of basic structure of this country, so NJAC is doing nothing but impinging upon independence of judiciary. It is violating the basic structure, and as it is violating the basic structure, such amendment is unconstitutional. As soon as Supreme Court stated that 99th constitutional amendment is unconstitutional, NJAC was struck down and the Collegium system again revived. So till then, as of now, the appointments to the judiciary, higher judiciary, judges of the Supreme Court and High Courts, they are made by the judiciary itself. So in this video, we have tried to understand how the CJI of India is appointed, how judges of Supreme Court are appointed and High Court are appointed, and all the relevant cases that are important for you to understand how Collegium system in India came into existence. So with this, we'll end the video. We'll meet with a new video with a new topic, and we'll discuss some legal angles. We'll explore some legal angles in the new video. So that's all for today. Thank you.